Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and this season is about shareholder litigation. We're going to offer you a civil procedure playbook as we walk through the entire process of how shareholders can take legal action when things go wrong in a company. Think of this as a guide with real-world insights. So whether you're a law student encountering these ideas and doctrines for the first time, a business owner wanting to protect your company, or just someone interested in how corporate accountability works in practice, this is the podcast for you. We'll use simple analogies and step-by-step explanations to build your understanding. Shareholder litigation is fundamentally about keeping companies honest. Imagine that you buy shares in a company, which makes you a shareholder. You're essentially a part owner. You literally own a share of the company. And you need to trust that the company's leaders, its directors and officers, will make smart decisions that grow your investment. But what if they don't? What if they hide bad news, or waste money, or make deals that only benefit themselves? Shareholder litigation is the legal way to step in and say, hey, that's not right. Fix it or pay up. It's like a built-in check on power. Shareholder litigation ensures companies stay transparent and fair. Without it, leaders could run wild and investors could lose trust. This all stems from core agency problems in corporations. Shareholders are principals. They're owners, but they delegate control to managers who are the agents. And agents might prioritize their own interests, creating what we call agency costs. And litigation helps reduce that by enforcing accountability. Not all shareholder suits are the same. There are two main categories: direct actions and derivative actions. In a direct action, you're suing because the harm was done to you as an individual shareholder. For example, the company might issue a press release saying, "Our new product is a huge success," but actually it's a flop, and they knew it. You read the release, you buy more shares, and when the truth comes out, your investment tanks. That's personal harm to you because you were lied to, along with perhaps an entire class of shareholders. So you, and maybe in a class action, can sue the company or its leaders to recover your losses. It's like if someone sells you a car claiming that it's perfect, but the engine fails the next day. You sue them for tricking you. The key here is that recovery goes to you, and the plaintiff is to you. So the shareholder is the direct plaintiff. And these are often based on harms that come from securities laws that protect investors from fraud or misrepresentation. So we'll be looking at some of those, like the Securities Act Rule 10b-5. And we'll contrast that with a derivative action. In a derivative action, the harm is to the entire company, which indirectly affects all shareholders, including you, typically by the value of the stock going down or the company being in some kind of trouble. The shareholder isn't suing for their own individual harm, or even as a class of people like them who was harmed. They're suing on behalf of the corporation. And they're suing to fix a problem the leaders caused or ignored, or a breach of a duty the director owed to the corporation. And so the harm is only derivatively to the shareholder, who is taking action on behalf of the corporation in this unusual instance. For example, if the directors approve a merger and they pay way too much for another company, but it's because the target company's CEO, who is a friend who gives them kickbacks, that overpayment is a waste of corporate assets and a breach of the duty of loyalty. But who is going to sue on behalf of the company that lost money? The board of directors who took the kickback won't sue themselves, so you need a shareholder to step in as a derivative plaintiff. Derivative meaning they derive their right from the company's injury as a second-order matter. And in a derivative action, if the plaintiff wins, the money or the remedy actually goes back to the company. It benefits all shareholders proportionally. You might get legal fees, if you're a lawyer, covered as a sort of thank you for stepping up. But it's fundamentally about the harm to the company, and then the recovery goes to the company, making it derivative. It's like living in an apartment building where the manager wastes rent money on personal stuff, and as a result, the building leaks. So the building is harmed, and a tenant sues on behalf of the cooperative for the building to get the money back, not just to get their own rent refunded. The setup prevents a flood of individuals suing for company-wide issues, and it ensures the corporation as a whole is made right. And there's also some safeguards we'll learn about because you can imagine this is a powerful tool. Derivative actions are particularly powerful for addressing agency costs because they force agents like managers to answer for self-serving behavior that harms principals like shareholders. This distinction drives the entire lawsuit process. In direct actions, you don't have to worry about asking the board for permission because you're making a personal claim. Derivative actions have more hurdles because we have an unusual situation where a shareholder is speaking for and acting for the company. So courts want to make sure it's necessary. The split also affects what evidence is required. In a direct claim, there's a focus on how you as a shareholder were misled, which is often about material reliance on misstatements. While derivative actions dig into board decisions like their fiduciary duties to the company. And remember, direct means cash back to the shareholder. Derivative means the company gets the recovery. And so the question really is the primary victim the shareholder or the company? And the answer to that usually tells you the type of shareholder litigation. Another decision would be the forum, the court you choose. And that's another strategic decision that can make or break a lawsuit. Delaware's Court of Chancery is a sort of superstar here. It's a specialty court with long-standing recognition for resolving business disputes efficiently and having expert judges in corporate law. It's also worth pointing out that they are under some pressure right now as some companies are threatening to leave and go to states like Texas, Nevada, and Wyoming, where some of those jurisdictions are talking about setting up their own courts of chancery to deal with business matters. But for now, most big companies are still incorporated in Delaware because laws are predictable and the judges do know their stuff. Cases could get resolved in weeks instead of years, especially for derivative claims about board oversight failures. It's like going to a specialist doctor for a heart issue instead of a general practitioner. Federal courts handle a lot of different actions and a lot of direct actions under securities laws, but they are stricter. Federal courts have rules like the Private Securities Litigation Reform Act that require super detailed complaints right from the start, leading to more early dismissals if your story isn't airtight. It can be hard to get the discovery to prove the material misstatement elements before the litigation even begins. Federal judges demand precise proof connecting company statements to stop losses. If the link is weak, the case goes out. Choosing the wrong forum is kind of like playing basketball on a soccer field. It just doesn't work. We'll also weave in emerging trends that are shaking things up because corporate law evolves with technology and society. Take the SEC's cybersecurity disclosure rules, please. They kicked in late 2023. If a company suffers a major hack, they have to report that to shareholders within 4 business days if it's quote-unquote material. Material meaning it could affect investment decisions. If they delay, that can trigger lawsuits. Material isn't just about the money lost, but if the news would change how a reasonable person views the stock. It can be hard to determine whether or not a particular hack meets this threshold, but there's a litigation risk if you don't do it. Another trend is artificial intelligence in legal work. Tools can scan thousands of documents to find key evidence, saving time and money, and potentially making it easier to find those facts to have a lawsuit. You can imagine sifting through a needle to find a haystack, or using AI like a magnet to pull it out. And meanwhile, blockchain is creating a way to make unchangeable, immutable digital records, like a permanent ledger that, at least from the technologist in me point of view, can't be faked. Well, there are some limits to that, of course, but the idea of an immutable, unfakeable ledger could prove timelines and facts in cases, and it could be used as evidence. And there are some courts that are now accepting blockchain-based evidence. So we've got a lot to cover here, and I'll try to fit these technological developments naturally as we go along into our seasons. The season is structured to build layer by layer. Episode 2 covers the difference between direct and derivative actions, and those first hurdles, which are standing and demand requirements, where you have to prove you're allowed to sue and have tried internal fixes and exhausted your other remedies. Episode 3 is about discovery, which is gathering evidence. Episode 4 is pretrial motions and direct suits to test the case early. Episode 5 dives into special litigation committees, which are in derivative suits, like internal investigators. Episode 6 expands on pretrial strategies like summary judgment, and Episode 7 is trials, settlements, and ADR, alternative dispute resolution. The truth is, most cases end here without a full courtroom battle. Episode 8 looks at emerging trends like digital tools and regulatory shifts, and then we wrap up with Episode 9, a strategic playbook that is intended to pull it all together with actionable tips. Each episode has recaps, hypotheticals, and checklists in the show notes, so you can follow along. By the time we're done, you'll see shareholder litigation as tools for accountability. It keeps companies ethical and investors protected. And so in our next episode, we'll delve into the critical distinction between direct and derivative actions, examining how standing and demand uniquely shape each type of claim. Until then, this is Professor Seth C. Oranburg, and this has been Organized.